What's this case all about? Well, what it basically boils down to is a review of the long-standing rule that requires remote sellers to have some form of a physical presence in a state before they're obligated to register to pay taxes, collect and remit taxes to that jurisdiction. This requirement of a physical presence to establish nexus, which is that connection to the state, first was introduced in the Bella Hess case in 1967. 25 years later, it was affirmed in Quill. So 1992 basically affirmed the fact that you had to have physical presence. Fast forward another quarter century, this time bringing suit against a bevy of respondents led by Wayfair. And Wayfair, of course, a furniture company who does a lot of remote sales. And they say, we think we've got a new approach to this that doesn't violate the rules. We're making a new statute and we want it reviewed to see if it's fair. New statute said, instead of physical presence, what we're proposing is that there's some threshold for economic benefit. In this case, $100,000 of business or 200 separate transactions. And if a seller has these things, then they're going to have to collect and remit taxes to us. So the court looked at it, and they looked at it against a rich tapestry of cases that have unfolded over the years that have resulted in a doctrine about what states can and cannot do under the Commerce Clause. And as it turns out, states can regulate interstate commerce legislatively as long as they don't discriminate or create an undue burden. The undue burden is at the heart of this case, because Quill was basically predicated on the notion that it would be an undue burden for remote sellers with no physical presence in a jurisdiction to have to go through all the hoopla to register and collect and pay the taxes, figure all that stuff out. The Wayfair court opinion said, well, not really. Things have changed, right? This is an e-commerce environment in which we're living. These companies are doing literally billions of dollars of sales. And is it really fair that someone puts a giant warehouse just outside of the borders of a particular state, sells with this multi-billion-dollar fueled, sort of e-commerce platform, and yet they don't have to pay taxes, while the little mom and pop shop store inside the borders of the state does? So that is what was at the heart of the case. And what ended up happening was, to everyone's surprise, the court overturned it. And the majority said, times they are changing, we have to recognize these differences. And oh, by the way, let's not forget that the Quill court got it wrong. And this is a reversal of an erroneous decision, because Quill basically took away the authority of the states to promulgate an otherwise rightful law under the Commerce Clause. And what that did was it created a bit of a conundrum, right? Because the only way after that South Dakota could have collected taxes from remote sellers was either by having the court overrule its own decision, as it did in this particular case, or having Congress act. Well, the court got all sorts of testimony and amicus briefs, as they usually do in cases like this, and everybody was quantifying the impact of what this meant. And what it means, according to the court, based on the averaging of all the data that was submitted to it, is that there's somewhere between $8 billion and $33 billion per year of taxes that are not being collected and remitted to the states. That's a pretty big range stipulated, but at a minimum, the total addressable market for uncollected tax is $8 billion a year, and at the maximum, over a 30-year period, we're talking about $1 trillion in tax. Worth playing for? Absolutely, which is why the states are lined up to follow South Dakota's lead and promulgate their own economic benefit standards by which they can charge and collect taxes from remote sellers. This creates a big burden from a compliance standpoint on a lot of companies who have to figure out how to charge these taxes, how to file their returns, what does it all mean? And it can be complicated, notwithstanding some of the newer frameworks that the court alluded to with the streamlined sales tax initiative, and the non-retroactive nature is certainly a nicety. But at the end of the day, there's going to have to be some advice and some tools that are applied with these companies that haven't been doing this to get them up to compliance, right? And that's where Ryan comes in. My division has tools that can help companies file and calculate all of these taxes. So we have a tax calculation engine that can calculate all the taxes based on all the things that are being sold into all the different jurisdictions. It's got all the tax rates. We've got a product that can produce and file the returns. And we also have products that manage some of the ancillary activities and documentation, including things like exemption certificates. Because now that a company may be obligated for the first time to register and charge and remit taxes to the jurisdiction, there are also exceptions to that, i.e. exemptions that have to be managed. So we have solutions to help with all of those things, and we work hand in glove with our counterparts at the rest of Ryan in the advisory areas to give you a holistic approach to figuring your way through the world in this post-Wayfair decision.